Good evening, ladies and gentlemen. My name is Matt Green. I am president of our local Federalist Society chapter here in Mobile, the Brevard Hand Alex Howard chapter. We're very excited tonight to be hosting former Inspector General Gerald Walpin tonight to discuss his new book, The Supreme Court versus the Constitution. I see a lot of new faces tonight. It's very excited. I think that's probably because of our speaker. For those of you who do not know, the Federalist Society is a nonpartisan, conservative and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community and the general public as well through its publications and presentations about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. Mr. Walsh, can we close that door? Thank you. Thank you. We got a lot of noise pollution. Thank you. Had the pleasure of picking up Mr. Walpin from the airport and had a delightful ride back to his hotel today. Discussed a little bit about the book and the state of affairs. I never thought that I would live to see the day that an Alabama case, the state of Alabama, would prevail in the United States Supreme Court. But the Voting Rights Act, for those of you who did not see today, the Shelby County case came down, a 5-4 decision where the preclearance requirements of Section 2 were ruled unconstitutional. And I was very surprised to see that apparently Chief Justice Roberts blew off the dust on the 10th Amendment, which apparently I thought had been dormant or no longer enforceable. But a very interesting opinion. I haven't read it all yet, but we talked a little bit about that on the way in. Several days ago, I sent an article to Mr. Walpin. The Wall Street Journal had written an article about the high rate of vacancies right now in the Inspector Generals in the Executive Department. Right now, for those of you who don't know, Inspector Generals they're basically government watchdogs for executive agencies to make sure there's no fraud, waste, mismanagement, or at worst, criminal activity and conduct. And the Wall Street Journal article said right now under the Obama administration, there are 9 vacancies right now that haven't been filled, and there's 3 right now that have been unfilled for 5 years or more. And these aren't just small executive agencies. We're talking about the State Department, the Department of the Interior, and Homeland Security. We're talking about $843 billion these executive agencies manage. And right now, in fact, the Labor Department hasn't had one since 2009, and I don't feel quite confident the new Labor Secretary nominee, Thomas Perez, will do anything to change that. Right now, there are 73 IGs and there are 9 vacancies. And I'm not sure if the IRS has one or not, but after reading the pornography and wine bills this morning on Drudge, it sounds like they need one or a new one. But Quinn Hillier actually helped line up our speaker tonight, and he couldn't make it tonight. But he did send a statement he asked me to read, and he asked me, he said, Gerald Walpin was the first public victim of Obama Chicago-style politics. He used a more colorful phrase, but I had to sanitize it. Against those who insist on clean and open government. In the course of writing numerous stories about his case, I discovered that Mr. Walpin was among the most honorable public servants imaginable. Government needs more people like Gerald Walpin at every level. A little bit about Mr. Walpin. He is a prominent New York attorney. He was nominated to the post of Inspector General of the Corporation for National and Community Service by President George W. Bush, and he was confirmed by the United States Senate and sworn into office on January 8, 2007. He led the Office of Inspector General, OIG, which was an independent federal agency charged with oversight over the taxpayer-supported corporation and its service programs, including AmeriCorps, Volunteers in Service to America, VISTA, and Senior Corps, serving in his role until 2009. As the Inspector General of the Corporation for National and Community Service, Mr. Walpin pursued a vigorous effort to investigate and prosecute all persons who betrayed the public trust by defrauding the corporation and its programs. And in particular, one case he may discuss in our Q&A session at the end after he talks about his book. A New York native, Mr. Walpin graduated from the College of the City of New York in 1952. He earned his law degree cum laude in 1955 from Yale Law School, where he was managing editor of the Yale Law Journal, From 1957 to 1960, he served as a lieutenant in the United States Air Force Judge Advocate General program. His career included a 5-year stint as Chief of Prosecutions for the United States Attorney for the Southern District of New York, where he successfully prosecuted a number of high-profile criminal cases. He spent more than 40 years as a senior partner and more recently of counsel to New York-based Catton Muchin Rosenman. Is that a polysyllabic Alabama phonetical for you? Mr. Walpin has represented a wide range of clients, including large public corporations, security brokerage firms, accounting firms, law firms, banks and lender liability claims, and individuals, both American and foreign, in securities litigations, employment litigations, criminal prosecutions, and investigations by the United States Securities and Exchange Commission. Both as an assistant U.S. attorney and in his law firm, he was frequently called upon to investigate fraudulent conduct, which I have no doubt President Bush called upon, one of the reasons why he called upon Mr. Walpin to head up his position with the Inspector General, as Inspector General. Included in the published compilation, The Best Lawyers in America, Mr. Walpin served from 2002 to 2004 as president of the Federal Bar Council, the Association of Attorneys Practicing in the Second Circuit Federal Courts. In 2003, he was honored with the American Inns of Court Professionalism Award for outstanding professionalism as an attorney and for mentoring younger lawyers. And for those of you who don't know, we have a very good American Inns of Court chapter here. Our local chapter here is very, very strong. Paul W. Brock Inns of Court chapter. Walpin and his wife, Sheila, have been married for more than 50 years, have 3 children and 6 grandchildren. It's hard to articulate 50 years worth of legal and public service, but I tried my best. Please join me in welcoming former Inspector General Gerald Walpin.
Well, you're taking... Thank you.
Pardon me.
No. Thank you, Matt. I really appreciate the invitation to come down here. I've never been in Mobile before, but this short visit, I think, will call upon me to bring my wife down at some point in the future. I particularly appreciate the fact that you have such confidence in my speaking ability that you don't have a translator. I want to start my talk by having you assume the role of appellate judges. I'm going to give you some fact situations. Consider this one. The defendant and the deceased were seen quarreling, following which a shot was fired, killing the deceased. Hours later, the police arrested the defendant in his boarding house room and asked him if he owned a gun. He responded, yes. Asked where it was, he directed the police to the washing machine where it was found. Ballistic tests established that the gun fired the fatal shot. A jury convicted the defendant of murder. No one even questioned that the defendant was guilty of that murder. Based on these facts, how many here would believe that the conviction should be thrown out and this murderer set free? I see no hands. Here's a second fact situation. Powell was convicted in state court of murder on evidence that included his possession of a revolver seized by the police when he was arrested without a warrant on a vagrancy charge 10 hours after the murder, plus expert testimony that the seized gun had killed the victim. Based on these facts, how many here believe the conviction should be thrown out and this murderer set free? Again, I see no hands. Now, you have had your play acting as judges and voted the way that I believe makes sense and that the Constitution requires. But taking us all back to reality, the Supreme Court majority set aside both convictions and freed both murderers to send them out to commit more crimes. I will get back to these cases and explain how that happened in a few minutes. But first, I will tell you something about my book. I wrote this book because I, like most of us, love this country. My book spotlights the unique gift that our founding fathers gave to us, a written Constitution that was intended to guarantee that this country would forever be governed by the rule of law, not the rule of men. Now, that's not an empty phrase. It isn't just something that sounds good. World history, as we know, has been full of autocrats and tyrants who ruled on the basis of their own bias, prejudice, and self-interest. Our written Constitution and the checks and balances it created were intended to prevent that. And while not perfect, the checks and balances have worked pretty well, with Congress checking the President checking the Congress, and the courts checking both the President and Congress, and add to it the check by the people through elections, because they check Congress and the President, as all of them are subject to re-election. But there's nothing similar with regard to the third branch of government, the courts, and especially the Supreme Court, that, as my book details, can have a very substantial impact on all Americans' rights, security, and values, and yet is not subject to any check or balancing by other branches of government, nor subject to being ousted in an election. Our country's founders, however, intended that the rule of law, not the rule of men, would govern Supreme Court justices as well as the President and Congress. So what does the rule of law mean as applied to justices? It means that they should not decide cases based on their personal views because they happen to be wearing robes, but what is in the Constitution and what our Constitution's authors intended by the words that they used in the Constitution. Thus, justices must uphold laws enacted by legislatures that do not violate the Constitution, whether or not the individual justice approves the laws. And likewise, they must declare unconstitutional those laws that violate the Constitution, no matter that they personally like the law. Before I get back to the cases on which you just acted as judges, let's examine one Supreme Court decision on which I would be surprised if anyone here today would disagree with me, that it was incorrectly decided because it represented activist judges substituting their personal views for what the Constitution mandated. I'm not sure if I had addressed an Alabama audience in 1868 and 1880 when this was involved, that I would get the same answer, but today I think I would. In 1868, as you know, the 14th Amendment was added to the Constitution, prohibiting all states from enforcing any law which shall deny to any person the equal protection of the laws. Despite those clear words, Louisiana arrested and convicted one Homer Plessy, who was 7/8 white and 1/8 black, for violating the state law that denied blacks the right to ride in railway coaches reserved for whites. When reviewed by the Supreme Court, the 7-justice majority admitted that, and I quote, "the object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law," unquote. Yet, they upheld the conviction. How did that happen? Simply, those justices substituted their personal bias of keeping blacks separate from whites for what the Constitution's words and intent required. Now, some would cast aside this sorry example as different from other examples where they agree with the bias that caused the justices to depart from the Constitution. But my book shows that either the Constitution controls or there is no control over justices who simply mandate their personal views. I will discuss here a few examples out of many in my book on which I show that a scant majority, often only 5, of the justices have substituted their personal views for what our founding fathers intended, often doing a 180-degree turnaround from prior decisions of the court, although, of course, as we know, the Constitution had not been changed. Let's look at one objective of government that affects all of us. Our governments, local, state, and federal, have the responsibility to go after and jail those people who have committed crimes endangering innocent people, such as murder, rape, and armed robbery. My book shows, with many examples, that a Supreme Court majority has, without any basis in the Constitution, imposed burdens on law enforcement that the Constitution does not require, and that up until recent decades, the Supreme Court itself had rejected. I get back to the first factual situation I gave you, the defendant whose gun was taken from the washing machine. Why, without questioning his guilt, did the Supreme Court free this undisputed murderer? The answer the court gave was that no Miranda warning was given before the defendant was asked if he owned a gun. The Miranda decision, by a 5-4 vote out of the blue, mandated a specific litany to be read to a person in custody, including, as we know, the right to remain silent, the right to have a lawyer. Most telling in the Miranda decision was that if the litany was not given, what the defendant said was excluded from evidence, no matter that the circumstances established that it was voluntarily given. Nothing in the Constitution required this litany. All that the Fifth Amendment, which anybody can read, all that it prescribes is that a confession to be used may not be compelled. It does not prohibit a person in custody from voluntarily giving a confession. And Miranda case was not the first time the Supreme Court had been asked to create a litany before a person could provide a confession. But each time before, the Supreme Court had rejected the idea. Each time, the Supreme Court pointed out that the Constitution prohibits only a compelled confession, requiring consideration by a jury or the judge of all the circumstances and not any predetermined formula. And what was the effect of the Miranda rule on law enforcement? Don't take my personal view. Take the view of the Supreme Court itself. The court, after the Miranda ruling, recognized that the Miranda exclusionary rule, and I quote, imposes a substantial cost on the societal interest in law enforcement by its proscription of what is concededly relevant evidence, unquote. So, contrary to over 150 years of court decisions, and without any words in the Constitution requiring it, 5 persons who happen to be wearing a robe created a rule that allows criminals to go free. Another important tool of law enforcement is physical evidence of guilt that police have uncovered. A dead body, a revolver that tests established was the murder weapon, and such evidence, if connected to the defendant by being in defendant's possession or bearing defendant's fingerprints, for example, is clearly independent and extremely convincing evidence of guilt. The reliability of such evidence does not depend on whether the police officer did or did not first obtain a warrant from a judge. That leads me to the second fact situation on which I asked you to act as judges. The Supreme Court there held that because the officer lacked probable cause to arrest Powell, the seized evidence was not admissible. And where did the majority of the Supreme Court find the rule that the results of a search, obviously relevant and trustworthy, should be excluded? The answer, again, is they simply created it out of whole cloth. The Fourth Amendment, any of you can read it, asserted to be the basis, has only 54 words in it, none of which provides that evidence obtained without a warrant must be excluded. Indeed, it probably will come as a surprise to many people here who haven't read the Fourth Amendment lately. It doesn't even require a warrant for police to perform a search or seize evidence lawfully. Justice Benjamin Cardozo, no slouch as a protector of civil liberties, succinctly said that the criminal should not go free, quote, because the constable has blundered. You may ask, how otherwise does society punish policemen who invade innocent people's homes, except by excluding the evidence? Well, think about it. The irony of the exclusionary rule is that it is useless when police invade an innocent person's home and seize personal effects. In such a situation, the exclusionary rule does not apply because no case is ever brought against that innocent person. The consequence of the exclusionary rule, again, I quote the Supreme Court itself, quote, the rule of exclusion of unquestionable evidence establishing guilt results in the escape of guilty persons and thus to commit more crimes. I add those last words. I turn to another subject that I consider in the book in detail, the effect of the First Amendment on pornography and computer games. One of the most ignored historical facts is that our founding fathers and the Supreme Court for many years thereafter considered the protection and enhancement of morality as one purpose our Constitution fixed for our country and government. Unfortunately, in recent decades, a majority in the Supreme Court has retreated from that view to substitute their personal elitist view of almost anything goes. Take pornography as an example. I won't nauseate you after this good meal with details of the rapes and murders that have immediately followed viewing pornography. In one of the horrible crimes detailed in my book, an expert for the defendant testified that the defendant committed as many as 24 rapes. The defendant's lawyer gave the cause of his client's conduct, and I quote, extensive viewing of rape pornography, unquote. Now, even before the 20th century, the Supreme Court had rejected any conflict between statutes barring pornography and the First Amendment. Pornography statutes, the court explained, were valid because they prevented, and I quote, distribution of matter deemed injurious to the public morals, unquote. Even Justice Brennan, known as a liberal defender of the First Amendment, wrote a court opinion explaining that, and I quote, obscenity is not protected by the freedoms of speech and the press, unquote. And those words were uttered because a unanimous Supreme Court had mandated two requirements for First Amendment protection. They must be ideas that have, and I quote, social value as a step to truth. And the second, their value must not be outweighed by the social interest in order and morality, unquote. Pornography hardly could be considered as meeting that dual standard. Criminalizing pornography had a long history embedded in our country's laws. Laws banning obscenity existed in each colony when they became states, and so too thereafter when each state was added. And the Supreme Court essentially copied the English case law on what is banned obscenity. I quote, the test of obscenity is whether the tendency of the matter is to deprave and corrupt those whose minds are open to such immoral influences, unquote, which the Supreme Court defined in a later case to mean the young and inexperienced. After almost 2 centuries of enunciating this rule of law, and with no change in the First Amendment, a majority of justices suddenly repudiated it. Most devastating among the changes the Supreme Court uttered most devastating to the prosecution of pornography was the court's decision that even the presence of explicit sex, no matter how lewd and lascivious, is not obscene as long as it is exhibited, and I quote, in a manner that advocates ideas or has any other form of social importance, unquote. So listen to the effect of that. I've created a hypothetical. The effect is that a hardcore pornographic movie can be distributed if it is titled, for example, Understanding Why Pornography Can Be Harmful, and you add a preface on the harmful impact of pornography, and it then can meet the court's emasculated standard of whatever you show is okay because it advocates an idea. I'll give you one very interesting example of the extreme to which some justices went to legitimate pornography. Justice William O. Douglas regularly sought to allow pornography. In one case involving a sexual autobiography, detailing with complete candor and detail the author's sexual experience from age 3 to age 36, Douglas relied on a statement by the Reverend George von Hilsheimer, a Baptist minister, to dissent from the court's ruling holding it was pornography and verboten pornography. In his opinion, Douglas extolled von Hilsheimer as having, and I quote, extensive experience as a group counselor, lecturer, and family counselor, unquote. Douglas went on to quote von Hilsheimer as using, and I quote him, the book insistently in my pastoral counseling and in my formal psychological counseling. He was also a psychologist, because it provides, and I'm continuing to quote, the history of a woman who has had sexual adventures outside the normally accepted bounds of marriage, and therefore gives the women to whom I give the book at least a sense that their own experiences are not unusual and that they themselves should not feel guilty because of their sexual activities, unquote. Calling this expert testimony, Douglas concluded, quote, I would think the Baptist minister's evaluation would be enough to satisfy the court's test that the book is not obscene. Now, what Douglas, I am sure, did not know, as Google now allows me to find out, von Hilsheimer plied women with this book to aid in fulfilling his own sexual desires. Women who attended the school that he ran testified that, I quote, he was a violent sexual predator, a serial rapist, and a pedophile who raped and brutalized countless underage female students, as well as some staff women. Florida, where his school was and where he practiced psychology, because of this conduct, revoked his license to practice psychology, but the statute of limitations had run on any criminal conduct. This pro-pornography justice's reliance on such an expert says much about the merits of their position. Another area in which the Supreme Court majority has substituted its own view of anything goes for centuries of contrary decisions without any change in the Constitution involves child pornography. For essentially 2 centuries, the court was unanimous that child pornography was verboten. Even Justices Brennan and Marshall, 2 of the most liberal justices on the court, agreed that the state has a special interest, and I quote, in protecting the well-being of our youth that affords the state the leeway to regulate pornographic material, unquote. No one disputed congressional findings that child pornography is harmful to children. And aside from the effect on the children involved, the greatest harm is on other children who are shown them, because an expert panel reported, quote, child pornography is often used as part of a method of seducing child victims, because a child who is reluctant to engage in sexually explicit photos can sometimes be convinced by viewing other children having fun participating in the activity, unquote. Yet, in 2002, not too long ago, a 6-justice majority held unconstitutional a federal statute that banned virtual child pornography, which is using modern technology to create sexually explicit images that appear to depict minors in lewd and lascivious, obscene activities. I share with you 2 reasons these 6 justices asserted that they knew better than the hundreds of congressmen and senators and the president who had signed the law, who believed the statute was needed to protect our youth. First, these justices argued that it's not so terrible that these pictures showed what appear to be 17-year-olds engaging in sexually explicit activity. Why? Because they said it is undeniable that some youths engage in sexual activity before the legal age, either on their own inclination or because they are victims of sexual abuse, unquote. Thus, these justices denied to Congress the right to lift the standards practiced by some young people. And here's the second reason the justices gave: because some movies made in Hollywood have portrayed teenage sex. I suggest to you it is a sorry day that our court looks to Hollywood for the controlling standard. I will now turn to my last example of the anything-goes mentality of a majority of the Supreme Court involving violent video games for minors. Obviously, my book has many other examples and many other subjects. What do you think of marketing to minors a video game that induces a minor to, and I quote, take on the identity and reenact the killings carried out by the perpetrators of the murders at Columbine High School and Virginia Tech, or allowing a minor, quote again, to rape a mother and her daughters, rape Native American women, engage in ethnic cleansing, fire a rifle shot into the head of President Kennedy as his motorcade passes by the Texas School Book Depository, unquote. California enacted legislation that made it a crime to sell such video games to minors without parental permission. A majority of Supreme Court justices struck down the statute as unconstitutional on First Amendment grounds, believe it or not. These few examples that I have mentioned are just a sampling of the many areas in which the Supreme Court majority has ignored the Constitution and usurped legislative powers that I fully document in my book. Other areas include the banning of God, legalizing abortion, rejecting most death penalties, rejecting certain prison terms, allowing profanity on the public airways, allowing disgusting, and I mean disgusting, animal cruelty movies, and even usurping Congress's role in dispersing taxpayer funds. As to all of these subjects, I respect everyone's right to disagree with me on the merits of any legislative action or inaction. You may believe in abortion or oppose it, death penalty or oppose it, pornography or oppose it, and all the other issues. But the question that I raise in the book is who should determine whether to allow, disallow, or regulate these actions. Should these decisions for our country be made by 5 individuals who happen to be Supreme Court justices, or by the thousands of elected representatives in Congress and state legislatures? Unless the words and intent of the Constitution clearly prohibit something, the Constitution left the issue to the people's representatives in legislatures. Unfortunately, a majority of the Supreme Court has usurped that power. And that is why I've written this book, and that's why I suggest that we all have our duty to make our voices heard when the next appointment to the court is made, to ensure that no one be confirmed who is unwilling to affirm, to live by his or her oath, to enforce the Constitution, and not render rulings on the basis of that justice's personal views of what the law should be when it is not. Thank you very much. I'm happy to take questions if our boss here allows it. Okay.
Will you tell us a little bit about your experience after when you I guess start us when you got the phone call and kind of the subsequent procedural history after that, and kind of fill everybody in as if they don't know what exactly happened, if you would.
Well, I'll start with the preface before that.
Okay.
The foundation. When I became Inspector General, I inherited a staff of non-political civil servants who were excellent, competent, and dedicated investigators, auditors, and support staff. And their job was to go out and find out the facts when a whistleblower had sent in a report something is wrong, or we got information in another manner. And they came to me with two different reports. One was on Kevin Johnson. Those of you who know basketball may remember his name. I didn't know it. He had received his entity, a school out west in Sacramento, California, had received a little more than, I think, $850,000 as a grant to assist the AmeriCorps workers who were working at the school to help teach underprivileged children. Our investigators gave me a well-documented report which showed that he had used that $850,000 for his own personal benefit. That was one. There was another report involving many, many millions of a grant that was going to the City University of New York, my hometown, which had an excellent program of bringing in teachers who had not taught yet, but given an opportunity to go for a master's degree while teaching in the very difficult schools. But the problem was, as the report given to me showed, there was no need for the millions of dollars that the federal government through AmeriCorps was giving it, because that program existed before the AmeriCorps money and was continuing without regard to it. And the statute said you can only give AmeriCorps money to meet unmet needs. Here it had been met already. So I, of course, approved proceeding against both. Well, I did not know that Kevin Johnson was a personal friend and political protege of President Obama, who had taken over the White House after 2 years I had been under President Bush. And I suddenly started getting, and the New York program was one of his favorite programs. So I started getting all sorts of pressures to drop both cases. Being the obstinate, principled person that I am, I refused. Finally, and we started proceeding. Well, finally, I was going up to a judicial conference, and they knew I would be gone. And I was in a car, and this was a Wednesday evening, late afternoon, 5 o'clock. Suddenly, my cell phone rings in the car, and it's the White House, saying, the president thinks it's time you moved on, and you have 1 hour to decide whether to resign or be fired. And, well, they called back in 3/4 of an hour, and I said that I will not resign. And I was fired. And it made a lot of headlines in the good press. The Wall Street Journal had a 2/3 page editorial supporting me. Quinn Hillier, who I should remark would make a fantastic congressman. Maybe I'm not allowed to be partisan, but he is a fantastic individual who I got to know in Washington. Very principled, very articulate, and he was very supportive. So that's what happens. I wear my firing as a badge of honor. Any other? My wife is happy to have me back in New York, though. And it isn't only 50 years, it's 56 years. Wow. Yes, sir. Was there a question back there or not? No. If there's no other questions, yes. Obama. Well, I don't know what else you can call it except Robert's opinion. You don't even have to go to the other four concurring judges. Robert's opinion was based on the fact that he called it a tax. Now, I don't know how a justice gets to call a statute a tax that Congress specifically in the legislative record and legislative history specifically denied was a tax. So it was activism. Why he was so motivated, some have said that he up until the last minute was voting to declare it unconstitutional and then suddenly changed. Was that after Obama made his attack on the court? And did Roberts want to protect the image of the Roberts Court? Your psychiatric analysis of Roberts is probably better than mine. Yes, sir.
Going back to one of your first comments about searches and seizures, what would be the remedy to an illegal search? Say if my house was searched for no reason, my car was searched for no reason, they find your cell phone, they find drugs, or my dog doesn't have his tags, or what have you, and I get arrested for that, I get prosecuted for that. What is the remedy if it's illegal, other than to suppress what is searched?
Well, I will answer. I will give you the remedy in a better hypothetical than your totally unreasonable one that you would have all those things in your house. Okay. Let's take an innocent person. Nothing is found, and the police, in the middle of the night, bang in the door and break it in, and you suffer not only embarrassment but probably some scary mental impact. There is a statute, and it's been used, where you can bring an action for monetary damages against the officials who either authorized the search or actually did it and entered your house improperly.
And attorney's fees.
And attorney's fees. And that's the real remedy. But why would you want the remedy of throwing out into the street again someone who has committed a crime? Now you can say, okay, marijuana, well, no innocent person is going to be harmed. But if you have a rule of an exclusionary rule, it applies also to a rapist and a murderer and an armed robber. Now, do you really think that society benefits by enforcing supposedly enforcing the Fourth Amendment, which doesn't even require it, by putting such a criminal out to harm some other innocent person?
Now, in your book, you mentioned that deterrence mechanism is almost a myth. Isn't that correct? I mean, that's the way in your book you described it, because you compared it, because the original Bill of Rights, the Fourth Amendment, didn't apply, the federal government didn't apply to the states, so you had a track record of comparison, and you said in your book that was really a non sequitur. Isn't that right?
You are 100% correct. And let me just state, the original exclusionary rule was enunciated by the Supreme Court only as affecting the federal government and federal authorities. So you had a number of years in which you could see in states that didn't have the exclusionary rule, see if the federal exclusionary rule somehow deterred mistakes by law enforcement officials. And most of these are mistakes, innocent mistakes, negligent mistakes. And there was no difference in the number of mistakes. Secondly, just logic shows that no law enforcement official is going to intentionally want to invade a home to seize good evidence if he believed there was reason to go in there and could get a warrant. So why would he spin his wheels, spend the time of breaking in negligently. It's like saying, why does somebody have an accident in an automobile negligently? There's no deterrence from having to pay the other party because you didn't want to have the accident to begin with. So too, most law enforcement officials want to have the ability to use the evidence they seize. Any other questions?
What do you think about the Defense of Marriage Act and gay marriage? The rulings are coming out maybe tomorrow even, or Thursday. What are your thoughts? What's going to happen? What do you predict?
Well, I am hopeful. I'm hopeful, but I don't know that I could predict. I'm hopeful from Ruth Ginsburg's statement. Ruth Ginsburg made an interesting statement about Roe v. Wade, which, by the way, is detailed in my book why that decision was based solely on the personal preferences of justices. Ruth Ginsburg said she wasn't on the court when Roe v. Wade was decided, but her personal view is that should have been left to the states, each state to decide, rather than having justices in the Supreme Court rule on such a controversial issue. Now, it seems to me that the same thing applies both to gay marriage, the DOMA action, as well as, what was the other one you asked me about?
There was another gay marriage case before the court, and it wasn't the Defense of Marriage Act.
Oh, that's right, the two gay marriage. I think that it should apply, but we'll see. I don't know how you predict what some of these justices. I was amazed at the decision last week where Justice Scalia dissented on a case. I'm glad he had a dissent, but I was shocked. Breyer was in the majority, and Scalia was in the minority on the right to use DNA evidence obtained from a swab in the cheek of somebody arrested for assault. Now, to me, that was a clear, easy decision. We fingerprint, no one doubts the right of the police to fingerprint somebody who's arrested for assault. Frankly, there's more difficulty in getting off the remnants of fingerprinting with the ink than there is in the little swab in the cheek that Maryland used for serious criminals or charged criminals who are arrested. What happened there was, so that in addition to the photograph and the fingerprinting, they put a little swab in the cheek and took out a DNA. 2 months later, that DNA matched with the DNA found in a woman who had been raped 9 years before. And of course, that was absolutely certain evidence that this man had committed that rape. And the Maryland court upheld the use of the DNA sample. The appellate courts in Maryland approved it, and it got to the Supreme Court. By a 5-4 vote, they approved it, but amazingly, Justice Breyer voted with a majority, and Justice Scalia wrote the dissent saying this was a violation of the Fourth Amendment. I don't understand it. Now, there may be one, if I can pose another issue, or do you want me to stop?
No, please go.
We've all been reading about the NSA program, the means by which the NSA obtains from all phone companies the numbers called and the number calling. And there's been a big furor with a great split within the right, within conservative people, and within Democrats supporting Obama. And I must say that I don't see the problem. The fact is that obtaining the phone numbers is no different from two law enforcement methods that have been upheld by the Supreme Court for decades. One is called mail cover, which is you look on the envelope, not the inside, to see who was sending the letter, the address of the sender, and the address and name of the sendee. And the Supreme Court has said it's entirely constitutional because what is on the outside of the envelope is known to be read by third parties and is not something that is private to any individual. When you send a letter, you know the post people are going to read what you put on the outside of your envelope. And so too, pen registers have been upheld by the Supreme Court. That is a gadget that law enforcement officials can put on anybody's phone, and all it takes down and gives information to law enforcement is the number from which the phone call is being made and the number to which it is made. And that recently, by the way, was used to apprehend some very good bank robbers who had gone through a series of 12 bank robberies where they would run in, quickly grab them, not bank robberies, silly jewelry store robberies. They would grab some very expensive watches or jewelry, run out, and on the 12th robbery of this sort, they were finally apprehended. You know how? The police checked what cell phones were being active in the area of the robberies before, shortly before, and shortly after. And one matched each of the robberies. And so they were able to apprehend that person. Now, if that can be done, and it's constitutional, for ordinary robberies and ordinary crime, when you have the terrorist threat against the United States, and that's not a fiction. You know that the first supreme leader of Khomeini of Iran after the takeover from the Shah at one point made the statement that he couldn't care less if Iran was destroyed and the people were all killed in a war, as long as in the end the rest of the world became Muslim. Now, with that mentality, you're facing a very serious problem in this country, and knowing what numbers in the United States are calling numbers in the area of Pakistan and Afghanistan held by Al-Qaeda and other Al-Qaeda locations is one of the best bits of evidence to start tracking. So what this program does is merely creates this computer of phone numbers called, and they don't find out what's in the calls unless and until, or who made the call, unless and until they get a warrant then from a FISA court based on the fact this was a call going to an Al-Qaeda stronghold. Now, that's a way of protecting America. So, I've given you this additional feeling. It's not in the book, but it's something that's contemporary. So, I thank you again very much. And Matt, you do a great job here with the Federalist Society, and I think it's wonderful. And I appreciate the invitation.
Thank you.